from Campus Law Center, Delhi University in 1999 after gaining a BCom degree from Sri Ram College of Commerce and another degree in Hotel Management from IHM Pusa. For the better part of his law school, he engaged in a long-term internship which prepared him to take on litigation with ease after as a fresh graduate. He is the founder of Sankla and Associates based out of New Delhi. Having founded Sankla and Associates nearly 20 years ago, Kapil Sankla is currently the managing partner of the firm. He has been in practice since 1999 and has been awarded the coveted Super Lawyer of the Year 2016. His experience covers a broad range of areas relating to dispute advisory, litigation and arbitration, corporate and commercial matters, white-collar crimes, employment, infrastructure, and aspect of public policy and administration, governance, and ethics. He has been listed as one of the leading lawyers in India in various publications from time to time. Thank you so much, sir, for joining us.
I
Now,
absolutely thank you.
I would like to request our founder, Mr. Zia Ansari, to welcome our speaker.
Uh, Good morning again, sir. First of all, I will like to inform all my participants the introduction which has been given by Apurva is very small about sir. Is something which a person who I follow very regularly. So I am a follower of yours, sir, from on LinkedIn and other mediums from very long time. Also, it's been an honor to have you on this board because I have been learning from your articles and everything and what you say. And recently, whatever you are posting, I'm continuously watching it. So I
Come on.
normally do not I normally do not watch, but the way you speak and where the sir express how he makes the subject with the practicality is something which always attracts me. Thank you very much, sir. On the board, please, it's up to you, and please enlighten us. We are all very excited to have you on the board. So, thank you.
Thank you. Thank you, all of you, for having me over. Honestly, it is such a pleasure that I get invited to forums such as this because, it also kind of makes me think we as lawyers tend to lose out on the basics of law. We as lawyers, what happens is the practicality of law takes over and we miss out on the theory of law. And theory of law is very important because it actually is the foundation on which good arguments are based. Anybody can come up with a story. On the criminal side, somebody once said that what makes a good criminal lawyer? He said a criminal lawyer is one who tells the better story than the other side. But there is much more to it. And I hope my voice is audible and everything is clear.
Yes, sir. Yes.
And fantastic, fantastic. So thank you all for having me over. It's such a pleasure. It's wonderful to meet youngsters who are so excited about law, who want to learn more, and it's a fantastic thing. Before we get on the root of the matter, so to say, talk about the mistakes in cross-examination. I'd just like to say this. There's a story that a senior lawyer once told me that you can learn more about law from one big matter than 100 small matters. I've been very blessed to do some phenomenally big matters in India. And so I not only learned from the best, but also learned in some of the best matters. So the tricks in those matters are on much higher scale. The judges are prepared, the prosecutor is one of the best, and the kind of preparation that you get into in this matter is very huge. But to prepare for that one big matter, you have to, and that is what the senior said, you have to be prepared and do those 100 small matters very well. So that if you're prepared with those 100 matters, you'll be able to do that one matter very, very well. So it's a very basic thing. What I'm going to do is, if you're like me, what you would like is bite-sized information. And that is what I propose to do, because the whole idea would be that, I'll give you a small pointer and this would be devoid of, sections and judgments and all of that. Not too much of it. I'll of course give you certain landmark judgments or judgments that I have used in court, but I will not really get into much of the theory of it, but get more on the practical of it. So without, any further delay, the topic is very interesting. It is about mistakes that young lawyers make during cross-examination. It can be on the criminal side as well as on the civil side. The effects of those mistakes. What would happen if there is a delay in cross-examining the witness? And also what would happen if there is a delay in examining the accused himself. Now, all of you know that the accused is examined under section 313, which is one of the major, so to say, pointers or one of the major achievement or goals in any criminal prosecution system. In a civil system, of course, the petitioner or the respondent or the defendant would come to the court to give his side of the story. If he fails to do that, there would be certain implications because only he or she would be able to take his case forward and prove his case. We will also quickly discuss what happens when false information is done. And I would be talking about another aspect of it because I've been a defense lawyer for more than 20 years. Though I've been as a special prosecutor in some matters, but as they say, the soul is that of a defense lawyer. So I will basically tell you the other part of the story that judges usually don't talk about. And if you're on the defense side, you might want to take this forward because I've been speaking about this in various forums. The general mistakes in law. We know that cross-examination is one of the most effective weapons in the arsenal of any lawyer. The fact is that cross-examination is never to be used just to confuse the other side or to confuse the case, which is something that a lot of people have said. A lot of people usually try to confuse or intimidate or browbeat the witness. Frankly, that's not a really good strategy. And why isn't it a good strategy? Is because when you are cross-examining the witness, you need to have the judge on your side. You need to make sure that the judges give you the kind of indulgence and leeway. And they will seldom give you that leeway if they feel that you're browbeating or you're harassing the poor witness. There could be situations where the witness himself would be a problematic witness. These witnesses usually are either police witnesses or witnesses who are in the government service, or those witnesses who see in the senior management, or those witnesses who feel that they're entitled to some power. Those witnesses are to be dealt in a different way than other witnesses, and we are going to deal with that. But first things first, what are you to do to be good at cross-examination and how to avoid certain major pitfalls? The first is, we have made some PowerPoints, but I'm not really good at it. So we'll avoid it.
You can share it. You can share it, sir. There is an option downstairs, green color, share screen.
Yeah, I know that, but it wasn't happening while I was talking to you.
Sir, I have activated it for you.
Doesn't matter. If it doesn't happen, it doesn't happen. We'll. It doesn't really affect my, discussion.
Sir, first open the PPT and then go for share screen. You might get that option there. First, open your PPT on the laptop.
Yes, I have the PPT on the laptop.
Open it first on the laptop and then open the Zoom. You will click on the share screen. You will get the PPT downstairs in some folder.
Okay. Have you managed it?
Yes, sir. Yes.
We have it on the screen?
No, right now we are not having it on the screen.
All right. Let me just try it once again. If it doesn't happen, we'll leave it and.
Sir, it's come. Sir, it has come. It's fine.
It has come. Lovely.
Yes.
Brilliant. All right. So this is where we were discussing right now. Yeah. So the first question is, what would be cross-examination? You guys have already heard this, so I'll not waste a lot of time. This is, go through section 154. And the whole idea of cross-examination is to bring forward the truth. Now, truth always has three sides. Now, this is the defense lawyer talking. It's always your, mine, and the absolute truth. The idea is to bring forth your truth. The absolute truth is something which is very theoretical. We don't know what it is. But what we do know is that irrespective in a civil matter or in a criminal matter, the other side is bringing their version of the truth. And it is your job to bring your version of the truth. So it's an extremely strong weapon. The pitfall that you would have is when you're not prepared. So pre-preparation is one. Always, when we talk about pre-preparation and not preparation, what we are talking about is know the general law. So know your Evidence Act, know the general law in which your matter would be. For example, civil matters, CPC, criminal matters, CRPC, IPC. Know the general law. Then know the special law, the statute, if there is a special statute in which your matter is coming, 138, for example, or when we are talking about, on the civil side, for example, matrimonial cases, or when we are talking about family cases, know the special statute, because all of them would have certain special requirements of cross-examination. Then always and always know your facts. Somebody once told me that you may falter on law, but you can never afford to falter on facts. The moment you falter on facts, you've lost the quote, and you've lost, so to say, the chain of thoughts. The moment you lose your chain of thoughts, you've got yourself in a big, huge hole, and it's very difficult to come out of. So know your facts. A very important thing on the criminal side, a mistake that is done, is when the file comes to you, and this is, we will also talk about civil side, but this is more for the criminal side. When a file comes to you, the IO in the charge sheet has put the site plan, and you've gone through the site plan and you're very comfortable with the site plan, and you think you can cross-examine and take on the world. You cannot. Somebody once said the map is not the territory, which basically means that the map could even be to scale, which it isn't. But you will not really know what really is happening till the time you do not go to the site and you inspect the site. I remember many, many years back, I was doing a matter, for a terrorist organization. The police, the case was that the terrorists had come to ISBT and had planted, or were attempting to plant, RDX there. And in that case, they had made the site plan of ISBT and had said that, the accused had come out from such and such place, had entered from such and such place. Interestingly, this case was fabricated. Interestingly, what had happened was that there had been fresh construction in ISBT. And this is really, really old, when you did not have the flyover that now comes to Tisazari from France Jamna. So that flyover was being constructed. And so when we went to the site, we were shocked to know that the site, the plan was completely different from what was the ground reality. And we actually managed to win the case on that point majorly. Because when we cross-examined the IO, the IO wasn't aware of this fact, and we were, and we had got our photographs done and all of that. Now, if you can't go to the site, even if you can't go to the site, then also please check out Google Map and a lot of other technologies that are there, because when you are able to do that, it will just be easier for you to prepare your cross-examination. Now, when the file comes to you on the civil side or the criminal side, irrespective, prepare your charts, which means write down the allegations which are there against you, or the story of the other side, how they're trying to prove it, if there is a document which is connected or not connected, if they have other witnesses that they are talking about in the narrative, or if it's a criminal case, in the list of witnesses, and the civil side, if they've disclosed those witnesses. So get your narrative right. The moment that is right, you would be very confident about the file, about the case. A lot of lawyers tend to make notes on the front, on the index. I tend to use a notebook for each and every case. I would suggest you do that, because then there is much more to write and to assimilate and to prepare, etc. Also be very, very aware, this is pre-preparation, that you are aware as to who the witness is and which document is filed and which witness is going to come and exhibit that. So one, there is a narrative. Second, the narrative has to be proven by the other side by a witness and document. So once you have the narrative right, and you put which witness will be called for which narrative and which document will be there, you will also know whether that witness is competent to exhibit that document or not. And the moment you are aware of that, you are also going to know where the weakness of the other side is. So it is very, very important. The second part of it is know the prosecution story and know your story. Or know the other side's story and know your story. You are always going to make mistakes if you are not aware of the other party's story, but more importantly, if you're not clear from the very beginning what your case is going to be, what your story is going to be. Because you cannot have a meandering cross-examination. And the moment you have a meandering cross-examination, you will never be able to prove your case. So extremely important to know what your story is, and always remember to follow that story. One of the biggest mistakes that most of the lawyers do is they have a general idea about their story, and then they go to the court and then they start cross-examining the witness, and they think, "Arey, I can probably take my story there as well." And so what they do is they digress from the story that they've created. They come to a completely different story. And then another witness comes and they, "Oh, this story does not work." And they try and come back to the previous story. It doesn't work like that. You would always confuse the court. You will always confuse the witness. You will always confuse your own story. You will always have a problem on the defense side, or when you are finally arguing your matter, irrespective whether it's again a civil matter or a criminal matter. A very important thing that I would like to share with you that is usually not spoken here in India, but something that I learned when we were doing a matter abroad, and we had some of the best lawyers in the world on the other side. This was an arbitration matter, but it was a fantastic learning experience. What it said was that know your long game and your short game. Basically what it means is that when you are getting up and cross-examining a particular witness, know exactly what you're going to cross-examine. What do you want from him? If you don't need anything important, don't cross-examine. Don't waste your time. Don't ever get into a fishing and rowing inquiry. The moment you do that, you will create a mess of your entire case. All right. So very, very importantly, what you're supposed to do is prepare the short game, know what questions and what documents the witness is there for, and the long game. The long game is your entire story. So you know the entire story and you've chunked it out into smaller bits as to, okay, this is a fact I have to get proven from this witness. This is the witness I have to break to make sure the chain is broken, etc., etc. And the long game as to what your story is going to be. So always have a short game and a long game in your mind. Note it down. It is always going to help you. Then, very important again is not having the complete command of the case. Again, as I have seen in a number of matters, what usually happens is that a lawyer reads the file peripherally and says, all right, I will deal with it when the time comes. The time is before you go to the court. You should be aware of the case, every witness, every document, and therefore the first advice, make your charts before you go to the court. Another big mistake that I've seen a lot of lawyers do, and this is not just young lawyers, this is also very established lawyers, that they don't prepare their cross-examination. A lot of lawyers like to be cowboys. They go to the court, they know the overall story and they say, "Arey, khel lenge, we'll manage it." You can never manage it. The most depressing thing that can ever happen to you is that you go to the court and you ask the questions that you're supposed to ask. And then when you come out of the court, after some time, you remember, oh, I could have formulated my question like this, or I could have asked my question, this question, which I didn't. And that's the most depressing thing. So always write down your cross-examination. And I'll tell you a wonderful strategy for preparing your cross. Two-pronged approach. One, first write down what you will never ask the witness or witnesses. Make an entire list of questions that you will never ask. Now that you know that the points you will never touch, you now can prepare the points that you're going to touch upon. Fantastic idea to ensure that you do not mess up your cross. The second is, always understand that any question can usually have three answers. Yes, no, I don't know, or I don't remember, right? So your question, how you make your cross, is on this three-pronged approach. If you want the witness to say yes, so the question is there. If he says yes, you finish that question. Don't again be a cowboy and think, oh, I'm going to ask him more questions. Let's see where it goes. It will go down the drain. If he says no, you have your next question prepared. Or if he says, I don't know, you have your next question prepared to close the loop, to get him to say what you want to say. The second most important thing is that at times a witness might not answer the way or react the way you want him to react. So you again do not keep pushing him at that time. If you have prepared your case and if you have prepared your cross-examination, you would know that this is the moment I stop asking him these questions. I will change track. Either you start asking him question on some other fact, or you should have some FAF questions prepared. FAF questions are not questions which are irrelevant, but questions which are very general in nature that do not really or cannot really harm your case. So that after 5 or 6 questions, when you have had your bearing and when you know that the witness is sidetracked, you can bring back the questions. So again, very, very important. Secondly, you should always write down the exhibits that a witness will do next to the witness itself. The moment you have that, you would know that this is the kind of, just a second guys, right. So you would know that, all right, these are the documents which necessarily have to be exhibited by the other side. Also, when you read the law, understand the concept of primary evidence and secondary evidence. The moment you have the concept of primary evidence and secondary evidence, you would know what documents cannot be exhibited by the other side. That's again extremely important. Another huge mistake that that a lot of lawyers do is that they're not vigilant reading the affidavit of evidence or when the chief examination is going on. A lot of leeway is taken while exhibiting documents, which could be again secondary evidences, photocopies, or documents to which the witness is not a witness to and therefore could not have exhibited. So be very vigilant at that stage so that you do not let the other side get one over you. The moment they have that one thing over you, they've already strengthened their case and you weakened their case. Supreme Court has said that if an objection is not taken at that very instance, then at a later or an appellate stage, you cannot take that defense that this document could not have been exhibited. So be prepared. It is extremely important. Another thing that I would like to tell you is, that's one of my favorite. A good lawyer knows what to ask. A great one knows when to shut up. So as a good lawyer, you have your cross prepared, you're asking those questions. If you got what you want, and if you know that this is what I was seeking, stop exploring, shut up. If you ask that one other question and the witness explains it, all your hard work has gone down the drain. So therefore, failure to set goals is an important aspect where a lot of mistakes are done. So set your goals, prepare accordingly, and thereafter, the moment you've got what you want, shut up. Don't ask another question. Don't explore. Don't get into, a fishing and rowing inquiry. A lot of young lawyers believe there cannot not be too much of cross-examination, where there of course can be. Another very important thing is that when you write the question down, ensure that you get the shortest possible answer. You let a witness explain himself. He will explain himself to kingdom come. You have a huge problem sorting the mess that you've created once you let a witness explain away his case. So therefore, if a witness is still, one of those die-hard witnesses who are hell-bent on explaining their cases, you shut him down. You say, I have asked you a specific question and therefore a narrowly tailored question. I have asked you a specific question. You please answer that, and whatever rest you want to say, you can say it as a volunteer statement. And a volunteer statement doesn't come from you. It's a statement made by the witness. It will not be harming you the way, a normal question answer would be. Now, so when we say narrowly tailored question, another aspect is that never ask a question without knowing its answer. If you don't know the answer, don't take a chance of asking that question. It is only going to create a lot of problems for you. And it is, and the problem again would be that the witness would start explaining himself, and you would have a lot of problem thereafter in your final argument to collate what is required and what is not required, because the other side is going to, of course, use it against you. So don't ask questions without a purpose. Very, very important. And now a very practical aspect of cross-examination. In the youngsters' language, put your game face on. Put your game face on means that when you are going to cross-examine someone, you are taking on an avatar. It is not you. It is not you, the nice, docile person, or that angry young man, or whosoever, whatever your personality is. Your game face is dependent on the witness that is coming. A very effective way, of course, is that you are extremely nice, sugar-coated. The witness feels extremely comfortable and says, "Arey, he doesn't know too much. He's such a nice guy or a nice girl." And he starts rambling, and you can get him to say whatever you want him to say. That is one way. The other is that you put pressure on him by being very overbearing. There is a problem with that because judges don't really appreciate that kind of cross-examination, but there's a trick to it. And the trick is that the moment you are overbearing and he reacts, you turn to the court and you say that, "My lord, please ask the witness, I am an officer of the court, please ask the witness to behave himself, please ask the witness to answer the questions. The witness, my lords, is answering back or retaliating, or my lords is not, my lords, talking properly, or whatever." The moment you point it out, you take away the fizz from that witness. The witness knows that, that he's in the court, he's not the boss, and that, you at this time are controlling the game. So put your game face on, very, very important. Now, another important mistake is not knowing the law of exhibiting documents. As I've said, primary and secondary evidence, electronic records, read section 62 of Indian Evidence Act. I think that is going to help you. But very, very important, you should be knowing what documents can be exhibited, what cannot be exhibited. If you get something that could not have been exhibited, you created a huge roadblock for yourself. Also now, when you read the other side's case, always know what he has admitted, because if you're going to touch what he's admitted or something that he's left out that is going to help you, that would be a professional harakiri, isn't it? I mean, somebody has already given you prasad by he not actually saying something that he was supposed to say to take his case forward, or admitted something which helps you. And in cross-examination, you ask a question and he explains himself out of it. Well, it's a harakiri. You created a mess. You were given blessing and you've rejected it. Again, as I said, know the law of evidence. Again, hearsay is a huge thing. A lot of times witnesses are brought in who heard somebody say something, and that becomes an evidence. Again, that's hearsay. You have to bring the source witness or the source document. That's basic law. So again, understand the fact, what the Evidence Act is, what the laws pertaining to exhibiting documents, etc. are. Never argue with your witness. Show him who's the boss. The best way to show him who's the boss is that if he starts arguing with you, point it out to the court. The court is any which way is busy. They really don't want a rambling witness. They want the witness to, say whatever he's supposed to say and get out. You can use this to your advantage. Point it out to the court. The moment you point it out to the court, the judge is going to, it is then between the court and the witness, and the court is going to take care of the witness. And you've shown that you're the boss. At this moment, you're the officer of the court and nothing else is more important. Just point out his demeanor to the court. The court is going to take care. One more mistake, very important, is that you have to learn to deal with facts, not with conclusions. If you ask if the cross-examination is, in your opinion, what do you think? The moment you ask that, you've opened the Pandora's box. You really don't know what the witness is going to say. And the fact you do not know what the witness is going to say is going to create huge amount of problems for you, right? Expert witnesses is another pointer where a lot of youngsters make a mistake. The trick with expert witnesses is to use one's intellect against the another, which basically means either if you have to cross-examine an expert witness, get another expert witness to make your cross-examination for you. He's going to tell you exactly what the loopholes in the other expert witness report is, and that's going to help you create a good cross-examination. Also get your own witness. You counter one with another. In your time, get your expert witness. If you can, it is going to discredit the first. Never ever attempt to attack the expert's opinion head on, because you really don't know how he's going to explain itself. He's of course an expert in this field, so he knows more than you, but you're an expert in cross-examination. So first you go round. about 3 questions to know the depth of his knowledge. The moment you think that you have an inroad, drive through, break his cross-examination, break his evidence, discredit him. Excellent. Now, another thing which a lot of people make a mistake is they let the other side ask leading questions from their own witnesses. Now, we all know leading questions is basically putting words in the mouth of the witness. You or the other side can never ask leading question from their own witness. The opposite side, of course, can. So you should know this because it's an extremely important thing. I would ask you if you've already been told, good. Otherwise, pertaining to leading questions, I would suggest that you read section 141, 142, and it would actually tell you what is the leading question, and again, what happens when you ask a leading question. So 142 will say that a leading question cannot be asked, and unless and until the other side does not object to it, etc., etc. There are 2 judgments to it, which I would suggest that you note down and you read pertaining to this. It is going to really help you. When it comes to leading questions, the one judgment is Varke Joseph versus State of Kerala. This is an excellent judgment, AIR 1993, Supreme Court 1892. And the Honorable Supreme Court in this said that the prosecutor, this is on the criminal side, ought not to be allowed to frame questions in such a manner which the witness may answer yes or no, so as to enable him to elicit such answers which he expects or desires. It also held that allowing such leading questions would offend the right of the accused to fair trial enshrined in Article 21 of the Constitution of India. Another judgment that you might want to note down is Mohinder Singh versus State. This is a 1970 judgment, Delhi. You can find out about it. It's ILR 1970, Volume 2, Delhi 854. This is again a brilliant judgment that says that the trial judge shall not permit questions which are scandalous, vexatious, or even cantankerous, which elicit irrelevant and inadmissible answers, or even those which do not advance trial but are calculated to hinder or delay the progress. So this pertains to how the cross-examination is supposed to take place. So please understand this, that you're not allowed to ask scandalous questions. You're not supposed to ask vexatious questions. You're not supposed to ask questions which are basically to confuse the witness. But if you think that it is going to take your case forward and the judge rejects it, then you can insist that the court notes down those questions and then says that those are disallowed. This helps you to, when you go to the higher court, to show that the questions that you needed to be asked, which you think are relevant but were not asked. I've already stated that be vigilant during the chief and when you read the affidavit, etc. There's a long-term gain that I would like to tell you to avoid a lot of mistakes. Never go without preparation. And trust the process of preparation. At times it would feel that, you're making too many notes, you're making too many of these charts, but in the long run, it is really, really going to help you. We've done some matters which were supposed to be of national importance that were in the newspaper every day. We were cross-examining witnesses after witnesses, and the stress was too high on us, on the entire team, on the other